Good evening and welcome to Slam the Gavel, a show that tells it all regarding family court, other court issues, as well as CPS. I am your host, Marianne Petrie. This episode of Slam the Gavel is sponsored by CPS Protect Consulting Services. Child Protective Services cases are among the most frightening experiences any parent can endure. Don't face them alone. With Urgent Assist by CPS Protect, you get the peace of mind to raise your children as you see fit and the personalized assistance of their team of expert child welfare consultants, former CPS investigators themselves, right when you need it. Get started absolutely free at cpsprotect.com/register. And this is available in all 50 states. One next announcement here, go to the site, pleasedoyourjob.com and sign the petition. We need 2,000 more signatures to get a case reopened. That's pleasedoyourjob.com. I have a brand new guest on. I'm very happy to have Tanawah Downing on. He is a chief legal strategist and a civil rights advocate, and I'm so pleased to have you on, Tanawah Downing. How are you this morning?
I'm good. Thank you for having me.
Great. How did you get into all of this?
Well, they say that experience is the best way to come to a new realization. And so, about 8 years ago, I went through a really brutal divorce myself, one that I didn't want, and I kind of changed my perspective a little bit. I started to realize there were a lot of people around me that I hadn't seen before that they were suffering and that needed help, and I just so happened to have knowledge and training and skills to be able to do that. So, my background is in substantive law as opposed to adjective law. I want to make sure that people are clear on that. Is that an attorney, they go through adjective law, so they learn the adjudication process, and so they learn about statutes, ordinances, customs, judge-made rulings. Those are things that remove freedom. So an attorney is really in the business of removing freedom. And we see that from the 13th Amendment. The 13th Amendment was the amendment that was created in order to abolish slavery. And it actually did nothing of the sort. It not only permits slavery, but it codified its legality within our foundational law. And so what the 13th Amendment says, it says neither slavery nor involuntary servitude shall exist except as punishment for crime. Well, then when we say except, it means you can't have slavery. So what they did was they told us the truth about what they were referring to when they say slaves. They're referring to prisoners. Prisoners is slaves, slaves, they're synonymous with one another. And so understanding that, when you see an attorney and you understand that they go through the process of making a person into a criminal, well, they have a degree in enslavement. That is what their degree is. So attorneys are in the business of removing freedom. I have a degree in substantive law. I went to George Washington University. I'm not an attorney. I wouldn't take the bar even if I could, because I'm in the business of restoring freedom. Substantive law is spirit or substance of the law, right? So I learned nothing but the Constitution. That's all I studied, laws of the United States. And so where they're in the business of removing freedom, I'm trained in the business of restoring freedom. And so, we're bringing some very, very major litigation to the United States Supreme Court. We hope to be there very, very soon. We have the case that's actually sitting there that's docketed. We have a very specific mechanism that we're using to get into the court to force them to actually hear it without discretion. And I'll explain that in just one moment. But so again, my degree is in substantive law. I'm known as an advocate. I speak on behalf of others, particularly in a legal matter. The reason why I'm able to do that is because I've been directly impacted by the law in question. So I'm able to bring the case on my own behalf and then speak on behalf of the other claimants, petitioners. And so, when it comes to this particular issue, it's been almost 8 years since I've seen or spoken to my kids. And although that's difficult, it was a necessary thing for me to have gone through so that I can understand what the group of petitioners are experiencing, so I can speak for them, and so I can actually express the true nature of these laws and the egregious acts that they deprivation rights that they cause. Mm-hmm. So.
Right. There's a lot of parents suffering from this. There's 22 million parents that are alienated from their children. And I believe family court perpetuates this, the judges, the attorneys.
Yeah. So they really do. And so, again, to get into the Supreme Court of the United States, there's one very, very specific mechanism that we're using, one particular provision. And so to get into the court, we're using what's known as the clause 1 of Amendment 5, which is the grand jury clause. And so what it says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. Well, there's 23 states across the nation right now that are not using a grand jury. They choose to charge by what's known as information. Well, according to Title 18, subsection 555, information can only be used for non-infamous crimes, for misdemeanors. So when you choose to charge a person by information as opposed to indictment, then obviously you're depriving a person of a right that's secured by enumerated in the Constitution of the United States. And as a result, that would be deprivation of rights under color of law, a violation of Title 18, subsection 242. So 242 says that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, violates that law. So again, when for instance, Oklahoma, well, the primary respondent is the state of Washington. Article 1, 26 of Washington State's Constitution says no grand jury shall be joined or summoned in any county. So that particular provision acts directly to the contrary of the United States Constitution, Clause 1, Amendment 5. And so as a result, those prosecutors are relying upon an inferior state statute to deprive a person of rights secured by the Constitution of the United States. That is a direct facial violation. It is a per se offense, and it's a crime. Now, what happens is that prosecuting attorney within the state of Washington, again, they're relying upon an inferior state statute to deprive a person of rights by the Constitution of the United States. When they do that, that is a crime. It's a violation Title 18, 242. When they hand that to the judge and they say, here, judge, hold this person over, that judge has a duty and responsibility to ensure that the power that he exercises is consistent with his authority. If it's not, exercises his power based upon someone else's abuse of power, that would also make him complicit. So the moment that judge signs it without having the correct charging instrument in place, that is now established in the conspiracy, Title 18, subsection 241. Then when that judge hands it off to the law enforcement officer to go out and make the arrest, of course, now you also have them complicit in it because they also have to make sure that the power they exercise is consistent with their authority. So that's the scenario that happens. All three of those are involved in a conspiracy to deprive of rights, willfully or negligently, it doesn't matter. And remember, this is a per se offense, meaning that they've already implicitly invited punishment should they fail to fulfill the promise. By their oath, the oath establishes their willfulness, right? Because you promise to fulfill a certain outcome. You promise to be obedient to what the Constitution of the United States demands and the requirements that it has put forth. And when you fail to do so, willfully or negligently, it doesn't matter, because when it comes to a public official, willful and negligence are of equal contemplation. So when you do that, now you have a pretty significant situation where it ends actually in the crime of kidnapping, because you did not have lawful authority to be able to do it. And of course, when this particular crime, Title 18, 242, occurs in conjunction with the kidnapping, the punishment is death. So this is a very serious offense. And this is the same thing that happens every single day with child support services. Okay? Because is in 1984, the United States Supreme Court came out and they declared that the right to intimate association was a fundamental constitutional right. It was found to be protected by the First Amendment. And so what the intimate association is that intimate association means that you have the right to have an intimate familial relationship with your child, and they have a right to have an intimate familial relationship with you without governmental interference. Now, limited reasons why they're able to take children away from their parents, very limited reasons. But what's happening is that CPS, you've got to remember, CPS is an agent of the state. They're operating under the enforcement branch of government, so under the executive branch. They perform their duties under the authority of the prosecuting attorney within the county that they reside within. And so when they come forward again to deprive a person of rights is guaranteed, found to be fundamental by the United States Supreme Court under the authority of state statute, they are committing a crime, deprivation of rights in color of law. Now, the issue is that that's not a facial constitutional violation, meaning that fundamental right is not enumerated or written within the Constitution of the United States. It's not written within it. You will not find the right to intimate association written within Amendment 1, but it has been declared to be fundamental. Therefore, we can proceed as though it's fundamental. Now, when you deal with a fundamental constitutional right, that is the most important right. It's known as civil liberties. Those are the ones that are specifically written within the Bill of Rights, the first 10 amendments to the United States Constitution. They are the most important to ensuring the fabric of our society and the sustainability of people. And so when you deal with a fundamental constitutional right, there is only one way that you can take it away. This is according to law. There are 4 different levels of judicial tests. The highest test is what's known as strict scrutiny, which requires the compelling state interest test. That is the highest test. And anytime you want to deprive a person of a fundamental constitutional right, you must pass strict scrutiny. It must pass the compelling state interest test. So the compelling state interest test basically says that there's absolutely nothing else that you can do except for deprive this person's right. There's nothing else that could possibly be done. And when when a state action is measured against strict scrutiny, oftentimes it loses because then it's determined that the state has exceeded their power of authority statutorily conferred upon them. So it's a very high measure to reach. But what is happening is the lowest level judicial test is what's known as the discretionary test, meaning the judge has the ability to use this discretion to deprive a person of his right. You cannot use discretion when applying or depriving a person of a fundamental constitutional right. You can't do it. And so that's what happens every single day. The CPS comes forward with what they believe is lawful authority to be able to deprive a person of his right, the fundamental constitutional right of intimate association. And when they do that, unfortunately, what's happening is that they are removing a right without the authority. They hand it to the judge and they ask the judge to remove this right based upon the allegation that they have. And the judge then uses his discretion to remove that right. Now you have the conspiracy once again established. When that judge hands this off to the CPS agent or the sheriff, whoever it might be, to go out and actually take that child away, now they're implicated in it, and now you have the exact same scenario that's occurring. Now, the reason why I'm moving with the indictment issue is obviously, we have a major issue that exists within the prison systems today. We have the mass incarceration phenomenon. We have all kinds of issues with the prison itself for the proliferation of the slavery institution. So constitutional violation, meaning that it is written in the Constitution. That is direct. It's very applicable. So once we get into the court through the use of the indictment by a grand jury, because bear in mind, there are more than 700,000 people across the United States of America today that are there illegally and unlawfully because they did not receive an indictment by a grand jury in accordance with the procedures and processes defined and codified within the Constitution of the United States. That is a major issue. And so I know that a lot of you, when you have CPS come in and they're starting to build a case against you, lots of times we're finding that these parents are being charged with crimes, but they're being charged with crimes that are arbitrary, that are capricious, that are not substantiated, and they're forcing you into scenarios such as, if you don't sign your child over, we're going to send you to prison for 10 years. These are direct threats upon a protected witness. And so the same thing is happening, whether it's the parents that are dealing with CPS or whether it's individuals that have been arrested arbitrarily without cause or legal justification. So this is a very, very significant situation. And not deprive a person of a fundamental constitutional right, certainly not through the use of judicial discretion. That is the lowest test. And so the last point that I want to make on this issue is that when you look at the abuse of discretion, right, because obviously this would be an abuse of discretion. When you go to the Circuit Court Handbook, the United States Circuit Court Handbook, and you look up abuse of discretion, they apply a two-part test to determine whether or not abuse of discretion has occurred. The first part is, did the judge render the decision? Did he apply the incorrect test? The answer is yes. He did. He was not supposed to use his discretion. He was supposed to use the compelling state interest test and strict scrutiny. He did not do it. Therefore, abuse of discretion did occur. Now, the second part of the test is any erroneous view of the law is an automatic abuse of discretion. Now, an erroneous view of the law, for instance, would be in the judge's legal contemplation, a state statute is inferior or is superior to the United States Constitution. That would be an obvious erroneous view of the law. Therefore, an abuse of discretion did occur. And anytime a public official abuses any discretionary authority with which he's invested in law, certain crimes occur, such as extortion, compelling a result through illegal means, such as perjury, he's failed to fulfill the promise, and oppression. So these are criminal acts, once again, that have already been implicitly invited punishment should they fail to fulfill the promise. So we need to put the issue onto the judges and prosecutors. We need to get their attention. We need to get it in a very, very serious and very, very quick way, because if we come forward in a slow approach, wanting to grab little bits and pieces of rights that have been deprived, we're not going to be successful in this. There's an old philosopher named Peter Parker that said that any nation seeking to correct gross injustices and move to liberal standing must be quick and decisive in its action. If it dithers, it will fail. We can't dither on this. We need to be quick and decisive. That's why we're moving forward with this in such a large manner. And here in a moment, I'll explain the tour and how we're going to do it.
Yeah, that's so very important. And people really don't understand this until it happens to them.
Yeah, that's an unfortunate thing. But they say that there's two types of fools in the world. There's those that choose to believe in something that isn't real, and there's those that refuse to believe in what is real. Mm-hmm. And we have a lot of fools in this nation. I was one of the fools. I used to be kind because I believed in something that wasn't real. And so I believed in America. I believe in American principles. I believed in everything that America stands for, that people that are in prison deserves to be there because innocence doesn't suffer. That we have a fair process, that you have the opportunity to confront your accusers. And I believed in these things because that's what I was told to believe in. And I think that we can believe in them. But there's a difference between theory and application. We don't know application until you're caught up in it, until you're a part of it. And so it's important that we realize that in order to share the same experience with someone else and understand what their reality is, we must suffer alongside them. And that's just God's way of preparing us. So, we each have our own reality, but that reality is based upon our experience. Mm-hmm. So that's why I say to you that if there's injustice in the world, you really couldn't understand me unless you've experienced it. Or if I had to say that there's racism in the world, you couldn't understand me unless you've experienced it. That's why two people can be standing side by side and yet have vastly differing perspectives on what's real and what's not. So you're absolutely right. There's a lot of people that don't understand what's going on because they've never experienced it. And so now we're in a situation where we have a lot of judges, a lot of people that are operating under lawful authority that are abusing their authority right and left, and doing it much more overtly than they ever did before. When you bring forward these issues and you explain to them, this is what the law states, and you're not following the law, do they stop? Absolutely not. Become even more overt about their actions. It's almost a catch me if you can scenario, and that's not acceptable. So when I first started this, I may have been a little bit naive in the beginning because I thought, I'm going to show them that they're doing wrong. They're going to change, and we're going to start doing things right. And that, of course, was me projecting, the fact that I personally would obey the laws. I would act in a good manner should I find out that I was failing to fulfill or be obedient to laws. That's what I would do. So I was projecting onto me, my own actions, my own behavior, and I found that that's not at all the case. So, when you look at the issue of criminality, and I got to say that a lot of CPS cases are intended to increase the criminality within our nation, because if you have a child that's removed from their family and the love and care of their parents, I don't care if that child is sleeping in a cardboard box in the street. That child would rather be with their parents than with someone that they don't know. They lose their sense of self the moment that they're removed from their parents because they don't have an image of man to look up to or an image of a woman to look up to. They don't know how to build lasting relationships. They don't know how to become a part of a communal society. And so we're hurting these children every single time we take them away. And they're now 80% more likely to go to prison as a result. So we have this that is self-sustaining, feeding itself. That's why we have an 800% increase in the prison population. That's why we have 16 times more prisoners than the next closest industrialized nation. That's why we have 4% of the world's human population, but 26% of the world's prison population is because we are destroying the familial unit in our desire to proliferate this industry and this business and to trade on the New York Stock Exchange in the form of Core Civic, Geo Group, and CCNA. And it's disgusting. So, the pursuit that I've been on, all that I care about is we've got to preserve the familial unit. That's the one thing that will keep a society together. A family can survive without a nation, but the nation cannot survive without the family.
I agree with you, and I couldn't have said that any better. People are not understanding why we are building so many prisons. We don't need to. First of all, there's a lot of people that are innocent sitting in there at taxpayers' expense that shouldn't even be in there. And as you said, unfortunately, with these poor kids being yanked out of, and some of them are yanked out of good fit homes just for the sake of money, kids for cash.
Yeah, I've seen a lot of it. I've talked to thousands of people, probably hundreds of thousands of people over the last few years, and the stories that I hear they're just egregious, and it's not just because remember, every day I get phone calls from others, right? Because there's a child that's in prison that's 40 years old. He's still her child and she still wants him back. And she'll say to me, my son didn't do this. He would never do it. I've come to believe in the things that mothers say to me because, for the most part, there's a connection there that we really can't explain. And when a mother calls me up and says, my son didn't do this, I'm going to tend to believe that statement. And so, if you were to open up the criminal procedure manual written by the Ninth Circuit Court of Appeals judge, and you were to open up to the preface, and you go down to paragraph number 4, it says most prosecutors across the United States agree that as much as 15% of people in prison are innocent, but that is acceptable deviance because our system isn't perfect. And I think that that's a great example as to what Americans believe in and believe is real. It's not. It's a lie. because we believe that innocence does not suffer. And yet the system itself just outright says that we believe 15% of people in prison are innocent, but too bad. It's just the luck of the draw. Here in America, innocence is not supposed to suffer. Benjamin Franklin, he said that it's better that 1,000 guilty go free than for one innocent man to suffer. And yet we have the system that's outright declaring that up to 15% of people in prison are innocent. I think that number is much higher. And if you look at the death penalty situation, our country has put to death 1,500 people, well, almost 1,500 people. Of those 1,500 people, 139 of them have been proven to have been innocent after they were murdered.
Oh.
That's terrible. That's almost 9%. And those are the ones we know of because there's still evidence available from DNA exoneration. That's what we know. And that's not good. So, if what we call good here in America, if it's out killing people with absolute impunity, or if it's robbing children from good families and loving parents with absolute impunity, if it's making rulings that's depriving people of rights and taking away the one mechanism that protects the innocent from hasty malicious charges, we can't call that good. Because if good is out there producing evil, it cannot be good because only evil can produce such a product. Good is incapable of such an act.
I know people talk about CPS reform and family court reform, but how do you reform something that is so corrupt?
That's a good question, but I think that so I think that the bulk of what's going on is cognitive dissonance, right? Cognitive dissonance is when your actions and your morals don't align with one another. So I don't believe for one second that judges or prosecutors, law enforcement, I don't believe that they're bad people. I certainly don't believe that they went into their career intending to be bad and producing the evil that they're producing. I don't believe that for one second. I believe that they're probably good people that believe that they're doing good things, but their separation between their actions and their morals, they're not aligning. And so they justify it. And they say, well, if we don't do it this way, if we don't take away this right, then look at this child that's going to remain in this abusive family, without actually understanding, the elements of what's occurring or other options. You don't need to take a child away when you could put the parents through marriage counseling or other options. But that's the first thing they do is they go directly to the removal of the child, the deprivation of right, without even an investigation. And so, the problem is that with that cognitive dissonance, right? They justify their actions so they don't have to deal with discomfort between the separation between their actions and morals. And so the only thing that you can do with these people when you experience someone that's doing cognitive dissonance is the truth. You have to speak the truth to them. So, with the judge, for instance, you have to call him honorable. Well, he's not honorable if he's violating the law. He's not honorable if he's committing felonies every single day. He's not honorable if he's threatening and intimidating people in order to fulfill his outcome of securing this individual and sending him off to a for-profit industry that we call sweatshop in China, but a prison here in America. That's not honorable. So we need to make sure that he understands, that those judges understand that you're a criminal. And as long as you are acting unlawfully in violation of the law, that's all that you are. That's all that you will ever be. You see, the truth will work on them, and it takes time, unfortunately. But what happens is that eventually their behavior, they start to recognize their behavior, and they start to see that, yes, what I'm doing is criminal. It's contrary to what I'm authorized to do, and it's detrimental to the people of the United States, and it's harming them and our nation. And so over time, they'll start to realize that their actions and morals are not aligning. They'll have to experience the discomfort from that, and then they'll have to address it, and they'll have to decide: do I want to be a criminal and thus maintain my behavior? Or do I want to change my behavior to align with my morals? And they should change their behavior to align with their morals. They will not change their morals to say I'm criminal and thus continue to commit the crimes. So the way that I like to say it is this, is that the issue of criminality, it cannot be solved the way that we're doing it. It can't be done from the bottom up, because we cannot go out and choose to just arrest the people, because if our country is being led by criminals, people are acting outside of the law and the code of conduct that's established and agreed upon by the majority, and the very laws that create their office and give them their authority, then that makes them a criminal, because a criminal is simply one that transgresses the law. It doesn't matter if it's the Constitution of the United States or it's a state statute. If you transgress the law, you're a criminal. So if our country is being led by criminals, we are going to be led toward criminality, which will then create an environment of criminality, and that will produce a society of criminals. So we cannot work this from the bottom up. We must go from the top down. We must first ensure that we have leaders. They're leading our country lawfully out of love, faith, obedience, and law, and the agreed upon code of conduct established by the majority. And once we do, then we will start producing a good society, because we'll be heading in a good direction. Today, we're heading in the wrong direction because we have the wrong people leading our country. We've got to change this, and we've got to draw this line in the sand, which is what I'm trying to do with the United States Supreme Court, and they're not very happy about it. But I'm drawing the line in the sand, and I'm saying this is what the law states. You are clearly operating outside of that law, and therefore you are acting unlawfully. Your actions are unlawful. And if your actions are unlawful, then what you are producing is also going to be unlawful. You cannot have a lawful outcome deriving from an unlawful act. So as we draw the line in the sand, we show them this is what the law states. Therefore, this is what your duties and responsibilities are. These are what your obligations are. Then when you act outside of those obligations, you are producing an unlawful result. So if you want to continue to act unlawfully, then we are going to come after you criminally. We are going to ensure that criminals are not leading our country, not leading the people, not making decisions that are depriving United States citizens of the rights that are guaranteed to us. We're gonna identify your criminality. We're going to pursue you criminally. But if you don't want to be a criminal, then you can return to the established rule of law, and you can work with us together to determine how we move forward consistent with the law. But there is no compromise. The law is the law. Dura lex, sed lex. It may be difficult, but it's the law. We must follow it. We must all follow it, because we don't live in a world where man creates the laws. We live in a world where we create the laws. The people of the United States create the laws. And if you are going to act outside of what we establish, then you have no lawful authority to my consent. You have no lawful authority to do anything to me. I will stop the obedience to you, not by willfully go out and commit crimes, but I will not respond to the things that you say, the demands that you make, because you no longer have authority to be able to rule, because your ruling is outside of the established rule of law.
Okay, because some parents that I've been talking to refuse to participate in the family court proceedings because they believe this is a fraudulent court, which I believe it's a fraudulent court,
Yeah.
and they just refused to participate.
Yeah, you know, they're able to do that. Now, it's not going to produce the outcome that you want, but the moment you participate, you are granting jurisdiction onto that court. Jurisdiction is the whole basis of the entire argument. It's going to be at the United States Supreme Court, the whole argument, and it's codified within Article 3. So again, to get to the court, we're using indictments as the main issue, right? That's a pretty big issue. 700,000 people that have direct facial constitutional violations and are being held unlawfully with convictions that are not valid because they derive from an unconstitutional act. If you breach the obligation in holding someone over for the trial and make that arrest without authority because you didn't have the proper documentation in place, then that results in an unconstitutional outcome. There's no denying that. But when we get there, the issue that we're going to be arguing is something that was litigated last in 1793 in a case called Chisholm versus Georgia. It was successfully litigated, and it goes on Article 3, Section 2. Now, Article 3, Section 2 says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. Okay? Now, again, all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So in order for a court to render a legally binding decision, it must have two things. It must have subject matter jurisdiction, and it must have personal jurisdiction. Subject matter jurisdiction is the right to oversee the type of cases brought before it. So for instance, in the case of a death, you would not bring that to a small claims court because it would not have subject matter jurisdiction to oversee the disposition of a deceased assets. You would bring it to a probate court. That would be the court that would have subject matter jurisdiction. Now, the second thing that it must have is it must have personal jurisdiction, which is the right to oversee the parties involved in a dispute. When the United States Constitution identifies two instances in which the United States Supreme Court has original jurisdiction, that means that it has exclusive personal jurisdiction when these two instances occur. And that is one, anytime a foreign dignitary is named a party, or two, anytime the state is named a party. If the state is named a party, the Supreme Court of the United States is the only court that has jurisdiction because they are the original jurisdiction court. No other court in the country can do it. And because that's an obligation that's codified within the Constitution of the United States, that means it is not delegatable. It is not discretionary. It must be performed. Anytime you have an obligation established and codified in the Constitution, that cannot be delegated, and it is not discretionary. They can't use discretion. So this has never been changed, right? We did partially change it with the 11th Amendment, right? But it only partially changed what had come from Chisholm versus Georgia. The 11th Amendment, if you were to read it, the 11th Amendment says that that a citizen in one state can't sue a different state. But nowhere in it does it say that you cannot sue your own state. Therefore, you do have the right to be able to sue your own state. But we won't get into the sovereign immunity issue. That's a whole other discussion that derives from 1890 in a case called Hans versus Louisiana. Nowhere in the Constitution is there codified sovereign immunity But that's beside the point. The point is that the Constitution codifies the obligation of the United States Supreme Court to oversee any case in which the state has become a party. Now, again, remember, in the very beginning, I said that CPS is an agent of the state. It's operating under the authority of the state, under the color of law, because they're using the law in order to deprive you of your right. Therefore, they are an agent of the state, operating under the executive branch, under the authority of the prosecuting attorney in the county, right? Therefore, they are an of the government. When they come forward and they do the things they're doing, of course, they're operating under the color of law, under the authority of the state. So the state is absolutely a party in the cause, right? Because James Madison, remember, James Madison is considered the father of our Constitution. He wrote Article 3, and he tells us, I mean, if you want to understand the reasons why they wrote the provisions of the Constitution, we oftentimes will go to the Federalist Papers. So it was written by John Jay, Alexander Hamilton, James Madison. James Madison wrote in the Federalist number 10, he said, "No man is allowed to be judged in his own cause, because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time." So when a state agency, CPS, coming forward under the authority of the prosecuting attorney, when they come forward with an allegation, right, to remove this right, when they are enforcing the law, right, then they are a part of that body of men that make up the state. And that body of men is not able to be both the accuser as well as also the judge. Therefore, the judge has a statutory obligation imposed by the Constitution of the United States to recuse himself anytime the state has become a party in any cause, because he cannot be presumed to be neutral and biased to oversee the disposition of that dispute. That judge does not have authority to proceed when it is a state agency that's enforcing the law, because that body of men that make up the state cannot be presumed to be neutral and biased when they're both the accuser and the judge. Therefore, that judge has proceeded in these cases without jurisdiction, and anytime the judge acts without jurisdiction, what results from that is a void judgment. Every single judgment, every action taken by the court is fully without force or effect, and that falls under Civil Rule 60B4. Civil Rule 60 deals with the nullification of judgments. When you go down to 60B4, it says that a judgment is either valid or void. It's valid in all instances except for when the court rendering the decision lacks either subject matter jurisdiction or personal jurisdiction. If it lacks either one of those two things, it is a void judgment, and a void judgment is always and forever void. It can never be valid because a court can never obtain jurisdiction when it lacks jurisdiction. Therefore, you can always challenge a void judgment. There's no statutory limitations on period of time. So what we're dealing with here is a massive number of litigants, huge number of litigants, an incredible number, because we're not just talking about people that are actively involved or that have had their child taken a couple of years ago. We're talking about every single family that has had this happen to them when the states have proceeded without lawful authority to do so because the judge had an obligation, constitutionally codified, to recuse himself. We're talking about every single prisoner who has had this occur to them ever since 1890. And we are talking about a massive number of litigants that potentially could come forward with this issue. And the whole point is that we have an opportunity right now to come forward with force to correct the system, to make them decide what they want to do. Because, you know, I'm not an advocate of violence at all, because I'm a patriot and I love my country. And a patriot is one that divine is one that loves and protects his country. But if you love something, then destruction should never be an optional outcome for that that's loved. I don't want to see destruction of this country. I want to see this country be successful. But the way that we're going to be successful is that we've got to get those that are leading us to recognize the criminality of their actions and to return to the established rule of law. But it's going to be on them, right? Because if we come forward in a hostile or forceful manner, then we're not going to have the power. They have the power. They have the weapons and everything else. They have that power. But we have the power of the Constitution of the United States. We have the supreme law of the land, and we can rely upon it and have faith in it and the things that it says, and don't rely upon a judge-made rulings, because judges do not make the law. There is a separation of powers that exists there. When a judge is only authorized to administer the law as written, the separation of powers identifies that the legislative branch, all legislative power, is vested in the legislative branch of the Congress of the United States, consisting of a Senate and a House of Representatives. So all power to make law derives from the legislative branch. So when the judicial branch steps forward and they say, I'm going to make this ruling and then I'm going to call it case law, we're believing that that's the law. But the judicial branch has authority to create the law, none. So when we call it law, then it lies to us. It's a misnomer. It confuses us. We don't rely upon that as the law. We rely upon the Constitution of the United States, the words that it says. And when we do that, then we can cut through all the bullshit that we're receiving from judges and prosecutors and everyone else that's telling us that they have the authority to do this. They don't. They don't. So, you know, once again, substantive law, what I do, I have the very, very rare understanding that any law that's not the Constitution is unconstitutional simply by virtue of the fact that it's not the Constitution. So when we argue for our rights, when we go to the high court of this country, when we go there, the only thing that we have to talk about is the Constitution of the United States of America. That is the only thing we have to talk, because no other laws apply. So when they try to draw us down into case law or state statutes, we're going to draw them back up to the Constitution. We're going to say, no, I'm not going to argue down at your level. You're going to come up to my level, and we're going to argue here. And when you do, you're going to lose, because you cannot refute those words that are stated within the Constitution of the United States. You can't do it. And so, you know, but the big problem is getting everybody organized, because, you know, like I said, there's a massive number of litigants. That's the challenge I'm having every single day is, you know, I'm going out there trying to increase awareness and make understanding of what's going on. One second here. I'm so sorry.
That's okay.
Okay. So we're trying to raise awareness and raise understanding of these issues. And, you know, people love what I'm saying, and they understand what I'm saying. But the problem is that getting them organized is really the challenge. So what I'm trying to do is, I've been to these courts numerous times. I've been to the United States District Courts so many times, trying to get them to resolve these issues, you know, trying to bring forward these criminal acts. And like I said, they're becoming more overt about it every single time that I go there. So I've been to the United States District Court in Tulsa. I've been to the one in Columbia, South Carolina, in Indianapolis, in Phoenix. You know, we've tried to get the courts to deal with these criminal acts being committed by agents of the judicial and executive branch. They're refusing to do it. So I, after the last visit to Phoenix, United States District Court, I went up to Las Vegas, and I decided to have a discussion with the U.S. attorneys there. And I said to them, I'm no longer going to ask criminals to stop committing crimes. And I'm no longer going to follow the rules of a system that fails to adhere to their own rules. So I said, the next time you see me, I'm going to be walking to the United States Supreme Court with 500,000 criminal affidavits on behalf of the people of the United States for these deprivation rights, the ones that I just told you about. And we're going to hand those to the justices, and we're going to say, what do you want to do about these crimes committed by agents of your branch under your authority that are punishable by death, right? And let them decide what they want to do. And if that's not enough, if 500,000 isn't enough, then we'll come back with 12 million the next time, because they're going to hear the case, and they're not going to have a choice, because again, when the obligation is statutorily codified within the Constitution, and it says that they have the duty and responsibility to oversee any case in which the state is a party, then they must hear it. So we're going in to invoke Article 3 as a United States citizen, and to say, you must hear my case. I'm not asking you to. I'm telling you, it's your obligation. You must hear it. And so, you know, so the criminal affidavits are very, very simple. I don't want to go into anything beyond the moment that the right was deprived, because when you do, then you're going into adjudication, you're going into a process that grants them jurisdiction. You're arguing elements of that. The only thing I care about is, on such and such day at such and such time, this person, whoever brought the allegation forward from CPS, this person did deprive you, the victim, of rights secured by and enumerated in the Constitution of the United States when they chose to deprive you of your right to intimate association under the authority of state statute. That's all it is said, nothing more. That establishes the crime of 242. Then the next part is that on such and such day at such and such time, this judge did conspire by and between the CPS person, you know, the person was identified in the first part, did deprive the victim of rights secured by and enumerated in the Constitution when they removed the child without lawful authority in violation of the Constitution of the United States. That's all we want to talk about. And then we're going to ask for the court to make the arrest and to hold them over for trial for the deprivation rights in color of law and for conspiracy to deprive of rights, those two offenses. We don't want to talk about anything beyond that. There's no other information that's necessary. Get a signature from the individual, and then we bring that in. Now, bear in mind, the right of intimate association, and this is something else that I'm working on. I'm not quite ready to tell you the whole plan, but when you deal with the right of intimate association, it goes two ways, right? It's not just one right. It goes two ways. So the right of intimate association goes to the parent, right, to have the right to be a parent, but it also goes to the child to have the right to be a child. So when you deal with the right of intimate association, If you want to remove that right with due process lawfully, you must have two different hearings going on. You must have a hearing that deals with the parent and the deprivation of their rights and the adjudication of removal of that to determine the parent unfit to be a parent. But at the same time, you must go through another proceeding to deprive the child, to determine the child is unfit to be a child. And so the problem here is that we have all of these children that have been taken from their family without any due process whatsoever. Their rights have been stolen from them without a hearing, without notification, nothing. They've been removed from these families without due process, and that right has been taken away.
Mm-hmm.
Now it gets even better, right? Because every single grandparent, every single brother, every single sister, every single aunt and uncle, they all have the right to have a relationship with that child as well. And the state is removing those rights without any due process whatsoever. There's grandparents out there that they lose their rights simply by virtue of their child lost rights. Now, right or wrong, the child lost the rights, but that grandparent did not. Mm-hmm. They're collateral damage, right? They're the removal and deprivation of rights without any lawful authority. So, these individuals, the grandparents, the children, they have had their rights removed without lawful cause, without authority, without due process. Every single one of them can come together, right, in a group and be able to say, I'm going to demand my child's rights, or I'm going to demand my grandchild's rights. Their rights have been taken away without due process. So what the court is expecting every single day is they're expecting you to argue for your rights. But Thomas Jefferson said, we gain civil rights as a result of choosing to defend and protect the rights of others. So they're expecting you to defend yourself. But if we turn and we go the opposite direction and we start defending those that are around us, we start defending the grandparents and the children, the siblings, their rights have all been deprived without any lawful authority, without due process. If we start arguing for them and their rights, then we bypass the entire state. We bypass all the courts. We go directly to the United States Supreme Court because it was, in fact, the state that deprived of that right. We go there under writ of habeas corpus, which is a judicial relief as opposed to litigation. And so with judicial relief, anybody can file a writ of habeas corpus on behalf of anyone that they feel is being deprived of their rights without due process. Anybody. So if you know that your child or your grandchild or your brother or sister had their rights removed without lawful authority, you would use a writ of habeas corpus, a judicial relief, to say, show me where the state had lawful authority to do this, right? And if they didn't, then they must restore the original liberty. So under writ of habeas corpus, you've only got a 32-day relief, right? It's at 32 days. You only need one justice. You don't even need quorum. You only need one justice to sign. And if so, then it requires restoration of those rights. So, if you were to come forward with these children and the rights that have been taken away from them with the writ of habeas corpus and say, this child has had their rights taken away without due process, show me where the lawful authority to do it is, show me the documentation that authorizes the state to do it, they won't be able to produce it because there was never a hearing associated with that individual. You're not arguing for yourself, you're arguing for them. Where's the documentation for them? And in doing so, we can come with a pretty significant group of petitioners here, argue on behalf of these children and actually restore their liberty. And by virtue of the restoration of the child's liberty, automatically the parents' liberty must be restored as well. So, I'm saying that, these are huge things that I'm talking about, huge. Mm-hmm. And I understand that they seem implausible and impossible, but, I believe in God. I know what he's directed me to do. And I know that with him, things they aren't as big as they would be otherwise. I don't see this as being a big deal because I believe in the people of the United States. I believe that we're good. I don't believe that we're a society of criminals. I believe that we're simply following our leaders. And I believe that once we're shown that what we're doing is wrong, that we're going to stand up and correct the behavior of those leaders, because across America, there are 40,000 judges, but there are 330 million people. Mm-hmm. Those 40,000 judges, they have no power when the people of the United States stand up and say, you no longer have authority. You're no longer in office. And so, we can do this, but it's going to take a lot of people. It's going to take a lot of people coming together, and it's going to take a lot of people giving up the things that happen to them in order to argue the base point, right? Because we want to find the common thread that affects every single one of us, right? We want to talk about it because, when you go and you talk about your instance where the prosecutor, didn't bring this information or this evidence forward, or the judge made this decision, he was being biased. That is one instance, right? Now it's happening on, but that's one instance. You have no power when you're talking as one. I have no power. I have the words that need to be said. I have the law that I can justify and uphold. But if I don't have people behind me, then I have no power, because there's no power in one. But the moment that we come together and we identify what is the common thread that affects every single one of these cases, and we go to jurisdiction, we say, did they have jurisdiction? Because that's the first question, very, very first question. Does the court render a decision have jurisdiction? And if they don't, then nothing else needs to be discussed. Nothing. So we can let go of the things that happen to us, come together under the common thread that's affecting every single one of us, the absence of jurisdiction. We talk about that. If we get 5 million people, or you said 22 million people are currently in the CPSs. If we get 22 million people talking about one issue, we're done. We're done. Here in America, it only takes 3% of the population to change anything in America, right? Anything. That's well known. 3% of population, that's 3 million people. We got everybody within the CPS system talking about the fact that the state lacks jurisdiction. We can change anything. We can do anything. And I believe in that. So,
right. When you got 20 million parents alienated via the family court system, what should they be doing to help you fix this?
So we need to be quick, because you know, the court and the legislators, they're going to be doing things to try to block this. And you know, the hardest part is, I'm at the court. I'm ready to go. You know, I've got the words. I've got the writ. It's already there. The problem is that we have to force them to hear the case, right? And we do that by numbers. So again, if I came back to the Supreme Court with 500,000 criminal affidavits from all these families that had their rights deprived, and remember, you know, I would have a criminal affidavit for the child, for the deprivation rights for him, to both parents. So there's 2, right? Then I would have both parents down to the child. That's another 2. We're at 4 with just one single family. 4 criminal affidavits for just one family, because that child had the right to be the child of the mother, had the right to be the child of the father. There's 2. The mother, child, the father, the child. We have 4 within one family alone, right? If I can get 500,000 of these, and I walk into the Supreme Court and I say, here you go, guys, what do you want to do about this? You see, when you deal with a criminal conspiracy, that's what it is. It's a conspiracy to deprive rights. It's a conspiracy to not uphold and enforce the laws of the United States. And when you swear an oath to the United States Constitution that you will be obedient to it, then every single person takes an oath. They have a duty and obligation to ensure that the power that they exercise is consistent with their authority. So even I swore an oath 23 years ago, and I will fulfill that oath because I have a duty and responsibility to do so. And so when I find someone that's warring against the Constitution, foreign or domestic, I have a statutory obligation to do exactly what I'm doing. And every single one of them do as well. So we want to give them an opportunity. We want to put this in their face. We want to say, you're doing things unlawfully, and let them decide what they want to do. Do you want to return the established rule of law, or do you want to be a criminal? Because what you're doing right now is criminal. And that will make you into a criminal. So, you know, we want to give them that opportunity, but we do that by numbers. If I come forward with 500,000 criminal affidavits and I hand them to the justices and I say, okay, you may not have known about this before, or you may not have realized what you're doing before, but you do now, and you have no choice. So when you're in a criminal conspiracy as a public official, it's willful or negligence. So under 1986, that any person who, having knowledge of any of the wrongs conspired to be done and mentioned in the preceding section, and who have the power to prevent or aid in the prevention of the commission of the same, neglects or refuses to do so, may be joined as defendants in the action. When you inform a public official of a criminal conspiracy that's occurring, particularly in violation of the United States Constitution, then they have to act. And if they don't, whether they willfully or negligently do it, it's irrelevant. They can be joined as defendants in the action. So we brought this to every public official. I brought it to every single United States senators through an action item request. I brought it to every single United States congressman through an action item request. Every single one of them have been informed of this issue through an action item request, where we asked the legislative branch to step up and begin investigations of these acts of deprivation of rights under color of law, investigate these, and then resolve it accordingly. They haven't done anything. Not one single congressman or senator has contacted me about the action item request that was sent out. In fact, they've come out. A number of them have come out and said, "You're not within my district. We're not even going to respond to this." So, you know, they're acting continual defiance as of this moment. And so, you know, at this point, there's only one thing left, one step left, and that's the Supreme Court of the United States. We've informed everybody. We brought this issue forward, and so after we go to the Supreme Court, if they refuse to fulfill the duties and obligations that they promised to fulfill, the laws of the United States, then the people of the United States are going to understand where we're at today. And we need it. We'll have to decide if this is the nation that we envisioned, and if not, then we need to decide as a people how we want to move forward. Because as of this moment, we have 50 individual regional governments that are acting autonomously, claiming that they have sovereignty, that they can rule the people in whatever way they see fit. They're depriving people of rights that are guaranteed. We need our leaders, particularly the Supreme Court, to step up. And if that court is what it says that it is, then it must assert its supremacy and make all the lower courts obey. If it is what it says that it is. If it's not, then I say go home, quit lying to us, and let us figure out what we're going to do to deal with these regional governments that are acting in oppressive nature, in tyrannical nature against the people of the United States. So I believe in the system. I believe in our laws. I believe in those justices as well. I believe that they're going to make the right decision, but I could be wrong. My faith could be completely off, and if so, I willfully will accept that I was a fool. But I'd rather be a fool than see the complete destruction of our nation.
Well, I don't think you would ever be a fool, but I also think Title IV, B, D, and E come into play with all of this money rolling in when every state this is a $50 billion a year business. I've seen CPS caseworkers lie on the witness stand, and I had been warned that whatever the CPS caseworker says, the judge will go along with their decision because they can't think for themselves. Also, I have taken a case to federal court where, again, collusion was there as well. When I handed off exhibits to the opposing attorney that was representing the corporation and two caseworkers, and he had stated to me, I know you've been to court, but this is how this case is going to go. I know both those judges in the federal courthouse. I'm going to get this case dismissed. And that's pretty much how it's going to go.
Yeah.
So I put that into an affidavit and submitted it to all parties. But I handed him the exhibits and I said, you have a nice day. But the thing is, there's so much collusion. There's so much money involved. How can we ever change this country? I mean, I want it done too. I'm with you.
Yeah. So the thing is that we're running government as though it's a business, just like you said. And a business, as long as we run a government as though it's a business, then we're going to focus on what's in the best fiscal consideration of the nation, as opposed to what's in the best societal consideration of the nation. We will make laws that will be specifically focused on generating revenue at the expense of citizenry. And that's what we have today. We have these laws that are put into place because a business is defined as they have to have three things. They have to create a product. They have to generate liability or pay liability and generate revenue. Those are three things. Well, government does none of those three things. They weren't designed to be a business. Government's not a business. We can't continue to run it as though it's a business. So you're absolutely right. How do we shut the business down? And this is what I propose. And it goes back to the criminal affidavits, because if I'm able to secure, right, if we bring this to a grand jury and we present to a grand jury these criminal affidavits for 500,000 instances across the United States, every single state that's acting in direct willful defiance of the Constitution of the United States, if I come forward with those 500,000 criminal affidavits, if I secure even one criminal indictment on a judge, prosecutor, and law enforcement officer in one state, the whole state shuts down, because every single judge, prosecutor, and law enforcement officer will be subject to the exact same offense. If I can secure 5 indictments in 5 states, that is 10% of the gross domestic product. We shut their business down. How do we make it more expensive for them to continue to do business unlawfully than it is to do it lawfully? We shut their business down. If they're not following the rules of their business, we shut it down. And so if we can secure one indictment, one set on those 3 that I called out, whether it's the indictment issue or whether it's the CPS issue, if we secure one single set on those 3 for conspiracy to private rights, the whole state must shut down. We secure 5 of those, and I guarantee you that the Supreme Court of the United States will be begging for us to come to D.C., have this argument, because they will want to figure out how they can move forward lawfully, because the business will be shut down. Their business is justice. Whether it's civil or criminal, that's their business. They make money off it. Their business is booming. We've got to figure out a way to make it more expensive to do business unlawfully than it is to do it lawfully. This is the way I'm proposing to do it. Let's shut the business down. Let's make it so that they can't operate anymore, because no business can operate when they're operating outside of the procedures and processes established within their organization. We could shut it down by simply bringing forward the law and forcing the law upon them and saying, if you're going to do things unlawfully, then you're not going to have the authority to operate anymore. Your
Mhm.
business will be shut. And so, again, this is a pretty big task, but it's not once you realize that once we come together, the power in the numbers, the argument is very simple. So, I know that individually, each one of these cases, that they're sickening. When they talk about, the collusion, when they talk about the judge being biased and the evidence is not being considered, or, all of these things are horrible, and they're an individual story that needs to be told, but there's a time and a place to tell that story, right? Right now is not the time. We need to get their attention first. And we'll do that by coming together in numbers, talking about the same issue that's affecting every single one of us, so we can earn the rights or receive the rights that are being deprived of us. Just as Thomas Jefferson said, we gain civil rights as a result of choosing to defend and protect the rights of others. So how do we get our own civil rights back? By choosing to defend and protect the rights of all those other people around us that are having their rights deprived. We do that by identifying the common thread among each one of us, arguing that issue, pushing that forward. Once we get their attention, you will have the opportunity to be able to tell your story, because we need to make sure that this country learns from its mistakes, because any country that doesn't learn from its history is doomed to repeat it. We don't want to repeat this ever again. The slavery institution that we've been proliferating since the establishment of our nation is the basis of all of this, right? We know that justice is about slavery. We know that justice is simply a term that was created by slave owners in order to preserve and protect their property. We know that. So it's time for us to decide if slavery is the foundation of our nation, and if so, is that how we want to be remembered? Because slavery has destroyed every single nation that's ever employed it. And we're on the brink of our own destruction because of our own ignorance in understanding that justice is not a matter of punitive. It's not a matter of punishment. It is a matter of public health, right? If you want to correct the morality of an individual, you don't do it by punishing them. You don't take a hurting person, put them into a hurtful situation and expect them to get better. You take that person and you deal with them from a health perspective. You teach him that he doesn't need to hurt anymore. And so all this hurt that we're creating from these children that we're robbing and stealing from their families, that are growing up without any sense of self, that have no direction, that are choosing drug abuse or choosing violence, these people are hurting. And so the one thing that I like to say is that we have got to stop looking at what people do, and we've got to start looking at what was done to them. Because when we look at what they do, all we see is the monster. They need to just pay for the done. And that creates this vengeance-based system, this penalty-based system that we have. But when you I'm so sorry. But when you look at what was done to them long before that crime, as a child, as a mother, as a husband, then you see that something tragic happened to them that changed the trajectory of their life, and it wasn't their fault. And now you want to heal them, you want to help them. You can see the reasons why they've done the things they've done. You see, that's where we need to be looking as a nation. We need to start saying, these are hurting people. These children are hurting. These adults they're hurting, and a hurting person hurts people. So we want to take that hurting person. We want to recognize that we need to heal that hurt so that they don't hurt other people. And we do that through public health. We don't do that through punitive. You don't punish someone that's already hurting. So, across the board, we need to understand that we are causing this as a nation individually. I'm responsible for the hurt that I inflicted upon my ex-wife. She's responsible for the hurt that's been inflicted upon me. We need to take responsibility for our role in the harm that we cause in those people around us, and we need to take responsibility for the actions that they do as a result of the hurt that we brought onto them. We just have this tendency to do things that are in our own best interest and not in someone else's best interest, and we need to stop. We need to start realizing that our behavior has a direct impact on someone else's behavior, and when we do that, then we can take responsibility and actually start moving forward in a much, much better and lawful manner.
Oh, I'm so glad we had this discussion, and I'd like to have you back on the podcast.
Yeah, I'd love to. Yeah, I know it's a lot of information that's fairly quick, but if you could, so we're doing the tour. It's We Shall Be Free tour. So what that is once we get this case docketed, right, and that's what we're pushing. Right now, it's with the clerk of court of the United States Supreme Court. He's refusing to docket it, and that's fine, right? That's fine. That's obstruction of justice. It's a crime, but I'm not worried about it, because just as Gandhi said, he said it's not the oppressor that needs to hear the truth. They know it and are busy concealing it. It's the oppressed that needs to hear the truth and not the oppressor. I will have my day in court. I will have the opportunity to say the things that need to be said. I will have the opportunity to be able to present this argument, and we will prevail, right? But it's not them that I need to fight with. because they already know what they're doing and they're busy concealing it. It's the people of the United States that needs to hear the truth, right? And that's what I'm trying to do at this point in time. I'm not going to waste my time going to judges, prosecutors, or the court system to inform them of their criminal acts. They already know it. We need to get this information out to the people of the United States. We need them to understand that these are rights that were guaranteed. And the moment that you arbitrarily take a right from one, you take it from all. Because any right that can be removed from one can be removed from all. And it's no longer a freedom, but an illusion of freedom. And so do we want to have those rights? And if so, then they cannot be removed from anyone. Because once we do, then they become a privilege and not a right.
Oh,
so again, what I'm doing is once this case is docketed, once we get past this last obstruction, the clerk of court, he steps out of the way and it actually goes into the hands of those justices. There's going to be about 40 days between the moment it's docketed and oral arguments. During that period of time, we're preparing what we're calling the We Shall Be Free tour. And that's going to be 40 press conferences at 40 state capitals over the course of 40 days. It's going to be very intense. We're going to be starting in Jefferson City, Missouri. We'll be ending in Washington, D.C. We'll be circling the whole country. That's what we're ramping up for. That's what I've been working on for the last 5 months is preparing for this tour. We want to support. This is an opportunity for everybody to come out, and that's when we're going to tell our story. Because when the people are silent, we give our consent. We allow government to do things to us that they would not otherwise be able to do because we don't speak up and speak out and demand that they do things right. But when government's silent, that is an indication of its guilt. Government will not engage you in a debate if they're wrong. If they can't win, they will not engage you in a debate. So we're going to bring this argument to their doorsteps. Once we're docketed and once we want to build that momentum, right? Because we got to get people to notice this. We got to get their attention. Once we start the tour, it's going to be back to back every single day. We'll be doing a different press conference, different rally at these state capitals all the way around the country. And when we do this, once we reach the Washington, D.C., there won't be a single news station in the country that won't be there to meet us, greet us, and watch us as we walk in to deliver the oral arguments on behalf of people in the United States. Now, this is a platform where you will have the opportunity now to tell your story. And government won't be there to come and defend themselves. So you will be able to control the narrative. I will be able to control the narrative. We're not going to talk about the things that you did. We're going to be talking about the things that was done to you by them on their doorsteps. And they're welcome to come out and debate us, but they won't do it because they won't be able to win on these arguments. So once we get docketed, that's when the tour will begin. It'll be 40 days. We're going to have an opportunity for all of you to come out, anybody that wants to be able to tell your story, be able to talk and have a platform to be able to do it. We want to tell this story again and again and again over those 40 days. We want everybody to hear these egregious things that have occurred to you and your family, the destruction of your family unit, the divorces, the removal of children. We want to hear those things. This is an opportunity for you to be able to do it. That's what we're trying to ramp up for right now. And so, again, once we have noticed that it is getting docketed, and at that point in time, then we will come forward and actually begin the tour. And that will be the platform that we'll use to tell your story.
That's excellent. That's probably the best news I've heard all day. Seriously.
Well,
how can people reach you with any questions?
Yeah, so my email is my first name. That's TAN, T as in Tom, A as in Apple, N as in Nancy, A as in Apple, W as in whiskey, A as in Apple, H as in hotel. Tanawah at we shall be free 2023.com. That's we shall be free 2023.com. That's my email. We have the domain, but we don't have the website up because I've been reluctant to put the website up because we don't have solid dates on tours. I don't know where I'm going to be from one day to the next. Mm-hmm. And so as a result, we don't have the ability to be able to actually put it out. So we've been a little bit reluctant on getting that out. Although I'm supposed to be leaving here in the next day or two, I'm going to a facility toward the East Coast where I'm going to remain until we finish collecting all these affidavits and actually get notification from court. It's not advantageous for me to continue to travel the way that I'm doing. I need to get more focused, get more content out, and actually be able to reach more people through a remote approach as opposed to direct. We'll have direct down the road. So in the next couple of days, I'm going to be traveling over there as soon as we get the funding to do it. And at that point in time, we're going to be putting out an automated affidavit within the website. So you'll be able to go there, be able to input the specific data that we need, the date, the judge, the prosecutor, your name, that information in particular, because every single one of them needs to be exactly the same. Exactly. We can't add anything else. And that's going to establish the class, right? And once we have the class at high enough number, then we'll be able to approach the court and be able to force them to actually hear the case through the invoking of Article 3 for this massive group of litigants that are prepared to stand up against these rights. So that's going to be coming forward. We have some people that are going to be helping with the website, getting it launched. The website is weshallbefree2023.com, and it will be up very soon. But if people want to get in touch with me, they can do it through email. That would be probably the best way.
Okay.
If there's groups of people across the country that need to hear this, if you have individual, groups within your domain that need to hear this, and you want to have me come and have this discussion, I would be more than happy to have a Zoom meeting. My time is free. I do this because I love my country and because I know that it's worth this fight. So I will go to any place. I will have any meeting. I will talk to anybody that will listen. And the whole point is we need to build awareness and understanding of the issue when you get on board with what is the common thread amongst all of us. And so if there's an opportunity that people have that would like to have me come and speak about these issues, I would be happy to do that. So, yeah.
Oh, excellent. I appreciate you coming on, and I'd like to have you come back for updates. And this has been really uplifting to me to hear all this.
No, thank you. Thank you very much. Yeah.
Well, hey, don't jump off. Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms. I am your host, Mary Ann Petrie, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poem of Truth, as well as Raised by These Wolves, How Family and Federal Courts Are Failing Our Children. Please join us again here in the future with Tanawah Downing and other exciting guests. You can find me on Spotify, YouTube, Apple iTunes, Anchor FM, iHeartRadio, and platforms I don't know about. And feel free to buy me a coffee to help keep this podcast going. You can find that in the podcast notes. And I totally appreciate you, Tanawah Downing. Thank you so very, very much.
God bless you all. Thank you.